Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And a very good evening to the lecturer, Dr. Akbar, and all the friends who are currently watching this. First of all, allow me to introduce myself. My name is Siti Ainan binti Muhammad Hamdani and my student number is 2018-645-166. Today, I am going to present a very interesting topic, which is Fasakh. A topic which is quite foreign to many of us in the sense that some people only had the opportunity to learn about Fasakh by attending a pre-marriage course. This topic is, however, very important to us, especially for women, as we have to educate ourselves to know our rights in marriage. Without further ado, let's go straight to the definition of Fasakh. So what is Fasakh? The term Fasakh on its surface refers to annulment or revocation of a deed. Fasakh, however, in a marriage context, refers to a method of dissolving a marriage by the authority granted to the judge. While the right to apply for Fasakh extends to both husband and wife, in practice, Fasakh is often opted by the women as the husband has the exclusive right to pronounce talaq. Unlike other methods for dissolution of marriage such as talaq, hulu and li'an that are specifically addressed in Al-Quran, Fasakh is, however, nowhere mentioned in any of the Quranic verses. However, the foundation of Fasakh can be inferred from a hadith by Prophet Muhammad sallallahu alaihi wasallam that says, "La darar wa la dirar," which means one must not harm himself nor bring harm to the other person. This hadith has highlighted two premises. The first one is that a person must not inflict harm to the other person, while the second premise is that we must avoid any kind of harm. So what does the term darar refers to in the context of marriage? Darar in marriage refers to any situation that causes the failure of any of the spouses to fulfill their obligations, hence preventing themselves to live in a good companionship to each other. Well, as known by many, the marriage relationship requires both husband and wife to fulfill their obligation. This can be seen in the Quranic verses in Al-Baqarah verse 228, which says, Bismillahirrahmanirrahim. Walahunna mithlu alladhina alayhinna bil ma'ruf walirijali alayhinna daraja wallahu azizun hakim, which means, and the women have rights over their husband similar to those of their husband that have the right over them to what is reasonable, but men have a higher degree of responsibility over them. This is also in line with a hadith narrated by Abu Hurairah that reported Prophet Muhammad when asked about a man who has nothing to offer for nafkah for his wife to separate themselves. Hence, we can see that Fasakh offers the solution for a married couple to dissolve the marriage in the event that there is any defect in any of the parties that result in their incapabilities to fulfill their role as a husband or a wife. The next question arises is, what amounts to ground for Fasakh? As according to a hadith narrated by Abu Dawud, the Prophet Muhammad sallallahu alaihi wasallam said, if any woman asks her husband for divorce without a strong reason, the order of paradise will be forbidden to her. This specific hadith has shown that the grounds for Fasakh must be solid and not a mere excuse. The four major Islamic school of thought has different opinions on the grounds for Fasakh. For Maliki school of thought, the allowed grounds are, firstly, if the husband physically mistreated the wife. The next allowed ground is if he failed to give nafkah or maintenance. The next ground is that if he is sexually incompetent to fulfill his nafkah batin or if he went missing or in jail. Next, Shafi'i and Hanbali school of thought are in agreement with the grounds for Fasakh. The allowed grounds for Shafi'i and Hanbali school of thought are: firstly, if the husband suffered a serious illnesses such as infertile, for example, sexual disease, or if he cannot afford to give maintenance due to insolvency. The next reason is if he went missing or in jail. However, the Hanafi school of thought has a different opinion. He refused to accept physical mistreatment as one of the grounds and any illnesses, except from sexual defects such as erectile dysfunction or mutilation of sex organ as one of the grounds for fasakh. In Malaysia, the dissolution of marriage by way of fasakh is duly governed by Section 52 of Islamic Family Law Act. That provision has laid down 12 circumstances from subsection A to subsection L that enable a wife to apply for fasakh. Among the grounds are: if the husband went missing for a period more than a year, if the husband failed to pay any form of maintenance for more than 3 months, or if the husband has been sentenced to imprisonment for a period of 3 years or more, and if the husband has failed to perform without reasonable cause his marital obligation or nafkah batin for a period of 1 year, or if he physically mistreated her. While several cases can be referred to when discussing about fasakh, our first case is Halijah binti Mat Sarat against Muhammad Idris bin Nordin. This is a 2009 case. The court allowed the claim for fasakh against the husband when it is evident that the husband has been cruel to her and even threatened to kill her. In another case of Ainun binti Abdul Majid against Muhammad Adam bin Bakar, a 2006 case, the court allowed the application of fasakh when the husband failed to give nafkah for more than 3 months. So, our next question is, what is the procedure to apply for fasakh? Contrary to popular belief, the procedure to apply for fasakh is quite simple. It will take more or less only 6 months. First and foremost, the applicant should fill in the required form and press it to the counter of the court. He or she shall also pay for the prescribed fee. Next, in the court at the decided date, both husband and wife shall present and the defendant will prove his or her defense. The next step is the trial. However, before the trial, both husband and wife shall appoint their own lawyer and prepare all the materials needed. During the trial, both parties will be given enough time to produce all this evidence, including their witnesses. This procedure may take up to 3 months. However, do take note that the trial may still be proceeded if one of the spouses does not attend the hearing. The next step is the judgment. If the court is in the agreement that the grounds for fasakh is fulfilled, the court will then give an order for divorce. The spouse will later go to the Islamic Religious Department to register their divorce, and a certificate of divorce will be issued. The effect of fasakh is that marriage will be annulled by the court. During the period of iddah, the husband cannot reconcile or rujuk to the wife. Furthermore, the wife who has been divorced by way of fasakh is not entitled to receive nafkah during iddah. And if the husband decides to remarry the wife, he must take a new akad and a new mahar. In all, we can see that fasakh offers a solution for the wife to escape from a misery such as abusive relationship, because it is no news that marriage life can sometimes be toxic. It is absolutely okay to find your own happiness, as the concept of fasakh is based on the fact that the institution of marriage is not something that is absolutely irrevocable or unbreakable, but a marriage may be dissolved once it is evident that the spouses can no longer live together in happiness in any account or defect in one another. That's all from me. Thank you for listening. Assalamualaikum warahmatullahi wabarakatuh.